Yeah, now she should move them back to the main room. So let's start.
A very good evening to you all and welcome. ACL is absolutely delighted to host this webinar where we'll be speaking about the Construction Payments Adjudication Bill of 2025. The bill is currently under public participation and comments are expected by 30th of June. So this is a very timely webinar, and we are going to be discussing how construction payment disputes will be handled under a statutory framework. This session is particularly special because it is ACL Kenya Chapter's first webinar. ACL Kenya Chapter is part of the larger ACL framework, which is a construction platform joining together construction professionals across Africa and the diaspora in bringing thought leadership in construction law and practice. For today, I'm joined by a very distinguished panel, and I will introduce them in the order in which they appear to me on screen. I will start by Desmond Odhiambo. Desmond Odhiambo is a partner at Cliff Decker Hofmeyer, a leading African law firm. He has 15 years experience providing dispute resolution, risk advisory, and regulatory services to clients in Kenya and various other African jurisdictions. He has particular experience in advising engineering, procurement, and construction contracts. He also advises on project-related insurance, including contractors' all risk insurance, public liability insurance, professional indemnity insurance, and other project-specific policies. He has represented clients in various complex arbitrations, whether ad hoc or institutional. He is a qualified mediator and a member of the Chartered Institute of Arbitrators Kenya branch. Welcome, Desmond.
Thank you, Paula. Glad to be here.
Next is Dr. Henry Kinyanjui Murugi. Dr. Henry Murugi is the Chief Executive Officer of the Nairobi Center for International Arbitration, NCIA, bringing over a decade of experience in alternative dispute resolution, mediation, arbitration, and litigation. A seasoned legal professional and academic, he has held key roles in both the public and private sectors, including as Principal Prosecution Counsel at the ODPP and a partner at Daniel Henry and Company Advocates. He holds a PhD in international relations and is widely published in the areas of justice and dispute resolution. Dr. Murigi is committed to positioning Nairobi as a leading hub for international arbitration and advancing access to justice across Africa. You're very welcome, Dr. Murigi. He's joining us all the way from the beach in Mombasa.
Thank you, Paula. Thank you so much, and good evening, everyone.
Next, I will go to Engineer Frederick Odhiambo Olwoch. Engineer Olwoch is a seasoned civil engineer, adjudicator, and arbitrator with over 18 years of experience in infrastructure development, contract management, and dispute resolution across East Africa. He is a fellow of both the Institute of Engineers of Kenya and the Chartered Institute of Arbitrators. He has served as a sole arbitrator, DAB and DAB chair, and expert witness in numerous high-value construction disputes. Engineer Olwoch holds advanced degrees in structural engineering, and construction law, and has worked on major water, transport, and energy projects as a consultant and a contract specialist. He is also a published thought leader and serves on multiple professional boards, advancing the use of ADR in the engineering and construction sector. Karibu sana, Engineer Watch. Last but not the least, we have Jacqueline Waihenya, who is a chartered arbitrator and emerita chair of the Chartered Institute of Arbitrators Kenya branch. She serves on the International Chamber of Commerce, ICC Kenya board. She holds a Master's of Law degree in the International Dispute Resolution from Queen Mary University of London. Her proficiency further expands to construction adjudication, holding an advanced certificate from CIRB. Her expertise bolstered by her connection to the Dispute Resolution Board Foundation, plus specialized training from King's College London and FIDIC in construction law. A chartered mediator accredited by the International Mediation Institute, FIFA Football Tribunal, and the Kenya Judiciary, she has played a key role in formulating Kenya National ADR Policy, Sessional Paper number 4 of 2024, having chaired the Legislative Proposal Subcommittee. She is listed in international arbitration panels, including CIRB, Nairobi's Center for International Arbitration, Arbitration Foundation of South Africa, ICC, the Shenzhen Court of International Arbitration. Jacqueline is an advocate of the High Court and managing partner of JWLM Law LLP. She holds a second LLM from the University of Nairobi, specializing in public finance and financial securities law, where she is also a doctorate fellow and a PhD candidate researching the regulation and governance of artificial intelligence, environmental social governance, and social sustainable finance. She is also a governance expert, chairman of the Institute of Certified Public Secretaries of Kenya, and is an accredited governance auditor. A committed scholar and a mentor, she is an adjunct lecturer at the University of Nairobi and contributes widely to ADR and governance literature. Thank you very much for joining us, Jackie. And lastly, myself, I am a construction professional with over 8 years experience in infrastructure project development and finance across Africa. I serve as the ACL Kenya chapter country representative, and I'm also part of the business development department at Motor Engine Africa and Latin America, where I play a key role in the preparation, structuring, and management of infrastructure projects from inception to financial close. I remain actively engaged in strategic advisory work and enjoy sharing insights with stakeholders across both public and private sector infrastructure initiatives. So it is indeed a pleasure to host this webinar and have this very timely discussion. We are looking at the Construction Payments Adjudication Bill of 2025, which is currently under public participation. The bill proposes a dedicated statutory adjudication framework for construction payment disputes, which could significantly change how payment claims are resolved in practice. So, without much further ado, I would like to lay the foundation for the bill. Jackie, maybe because you are part of the team that was drafting this bill, perhaps you could lay the foundation by giving us some of the practical considerations you had when drafting the bill and the reasoning behind it.
Okay, thank you very much, Paula, and also greetings to all the panelists and the attendees today. It is really a great pleasure to be here with ACL Kenya, and congratulations on your very first webinar. We are glad to be partnering with you as you launch the Kenyan look of ACL. You've done great things in around Africa, and we're looking forward to what you're going to be able to achieve here in the homeland. So, like Paula mentioned, I had the privilege of sitting in the we call it the National Steering Committee, which came up with session of paper number 4 of 2024. By that, I mean the draft that was sent to the Attorney General. We sent it in 2021, and you can see bill making, legislating takes quite a while. What I can say is that the Construction Payments Adjudication Bill is an initiative that we came up with as the committee. We were chaired by Senior Counsel John Ohaga, Chartered Arbitrator, also very keen on this policy. And when we considered, because I think from the start, I need to say this, we had more than 600 stakeholders who participated in coming up with the policy. They gave their representations, and in addition to that, they made contributions to what became the baseline study. And after the baseline, there was a first zero draft. And then from the zero draft, the committee then took it to what has turned out to be the policy. And we had a lot of exciting exchanges with our stakeholders, and particularly with the members of the committee, about what we wanted to see in our ADR space. And we fell back, of course, on Article 159 of the Constitution, and which names very many mechanisms, but does not name construction adjudication. So when we started discussing, we felt that there was a need to make a specific provision that would speak to the construction industry, because first, the construction industry does contribute to its fair share of dispute resolution in the country, and not only the country, the region, the continent, and also the world. And when we started the discussion, then of course, the next issue that came to the fore was, what was this going to look like? We want a statutory framework, but we don't want to interfere with a contractual existing traditional framework that has worked for the construction industry well for many, many decades. But we also knew, and I think that some of the discussions came in because that was a time when dispute avoidance became a topical issue. We also knew that dispute avoidance also needed to be considered. And being a student myself of adjudication certifications myself, of course, I'm well aware of the housing grants and the construction law framework that has emerged from the UK. So we came up with, initially we called it the Construction Adjudication Bill. And this is what we wanted to cover, to protect the contract. So therefore, we would start with an agreement to adjudicate that you see in section 4. But the key thing that we're looking at is, yes, there's an agreement to adjudicate, but an agreement in which context? So in the definitions part of the contract of the bill, we then looked at the new things that would be defined. And they are listed, they're quite a number, but of key focus was, what is a construction contract? How does it interface with construction work? So we tried to list what we imagined would fall under the framework of the bill. So it's an agreement to adjudicate, and it needs to be in relation to construction work. And then we asked, what was the main pain area? And the question, the real issue, the real problem, what everybody in the construction industry says is that our payments are the problem. So we came to revolve around the certificate. I think everybody in the construction field is familiar with the key role the certificates play. You sit, you first of all, there's a contract, you do the work, and then you have to value what has been done, and somebody will come up with a certificate, usually the engineer or the project manager. That is what the contract says, the contract administrator. But then at the end of it all, we know that many disputes have arisen in the agreeing of that payment certificate. So this act really is aimed at dealing with the question of the payment certificate, and how and where we can expect there to be problems or challenges, or where we think it would be useful for the law to intervene. So of course, there are those schedules. There's an installment, there's payment, or the first certificate, second, third, maybe up to 9, maybe even more. How does this come? Interestingly, we had a discussion on the same bill, and somebody came and said, now we also need to make a provision for outlawing pay when paid clauses in agreements and things like that. So that is something that we might want to put a pin on. And then when there is a dispute, then the parties can refer it to adjudication. That is all we wanted to provide for. And then we provided for a procedure. You will look at it, we'll try and look at the detail of what the procedure is all about and the number of disputes that can be adjudicated. And then we said, we don't want strict rules of evidence to apply. So we borrowed from what happens in arbitration and we said the Evidence Act shall not apply. The ultimate outcome of the adjudication process is the adjudication decision, which we set out at section 15. And we said we'd have a reasoned decision and would also, in line with practice, have an adjudication certificate, a one-page that sets out the key details from the name of the parties to the amount to be paid, the date that the payment will be made, the amount payable, who is to pay, and if there's any other remedy that has been granted, then we should also be able to provide for that. In case of challenges, we gave the adjudicator powers to amend in very limited circumstances. And then we said the philosophy behind adjudication is pay now, argue later. So we also made provision for the payment of the adjudicated amount and then to see how enforcement would be done, and also then to provide for setting aside applications as well, so that we enforce the philosophy of pay now, argue later. And we said that the court's intervention would be limited to matters in the Act. And then the decision of the High Court would be final, not subject to appeal. So the other issue that we really thought through was who is an adjudicator, who can be appointed as an adjudicator, what is their powers. First of all, they need to be independent and impartial. They must not have a conflict of interest, and they need to come from an adjudication, a construction adjudication body, and then to create a responsibility on the construction adjudication body to provide a report, to manage the people in that space, and also to discipline. And then we said, if an adjudicator is going to be appointed and we're going to put all these qualifications, then we need their adjudication fees to be, and their expenses to be secured. And we made the fees jointly, severally responsible, and provided for a right of lien for the adjudicator. And we talked about when the adjudication comes to an end. Exclusion of liability is also provided for, codes of practice. And then we said, because the philosophy of the overarching and to fit in with the rest of the ADR spectrum in Kenya, we would also provide for rulemakings by the Attorney General. And this is because we foresee an area, a situation where we're creating this, I want to call it an animal, this thing, a practice area committee, so that construction adjudicators are managed by construction adjudicators, mediators the same, and arbitrators the same. Yeah, so in a nutshell, that is a framework that we're looking at. I know for everybody in this space, and particularly those who are also coming from outside of Kenya, you might want to know that, yes, we said we will provide for this act to apply to construction agreements and construction. Let me read it for you. Wholly or partly from Kenya. So if you get a construction, a landscaper, it is possible from Kenya, and you do the work in Uganda, Kampala, it might still fall under this particular act. So it's important that we look at it from a national perspective to fill the gap that we have. We also need to appreciate that it may have application outside of our borders. And the other thing is that we can expect that there'll be professionals moving in and out of different jurisdictions, because construction is really an international space. It's cross-border, and when you look at the teams, you have everybody from everywhere. So this is a great initiative, I think. I don't know whether I should be saying this myself or waiting to be honored, but I do believe that should we get past the post, then Kenya will be the very first jurisdiction in Africa to have a Construction Adjudication Bill Act by whatever name. Sorry, Engineer Alwach, I know this is usually your line, but I've gone first before you. And I know you have a great deal more to say, but I do believe, and this I'll say for the benefit of the professionals, when they put construction framework in the UK, everybody now refers to them. Who knows, for Africa, this could be it, the reference point. So we stand at a really, really interesting and important point. Thank you so much, Paula and my fellow colleagues.
Thank you so much, Jackie. And you have really done a good job in laying the foundation of the practical considerations behind the Act. If I do say so myself, I think you did a great job. It's a very timely conversation that needs to be done, especially in light of the discussions on dispute boards generally. I think I would like to now move to Desmond, and perhaps you can walk us through the key features of the adjudication process, especially in comparison to other construction contracts that are normally used in this jurisdiction, for example, FIDIC and the rest of them.
Okay, thanks, Paula. So I think Jackie has done a very good job in terms of just laying the foundation. So I'll probably just go into a bit more detail in terms of, in terms of the scope and in terms of the timelines for, filing your payment claims and so forth. So allow me just to share some slides and just let me know if you're able to see it.
Yes.
Okay. So I think the first thing that Jackie mentioned, which is important, is that there must be an agreement to adjudicate. And that agreement to adjudicate is, to adjudicate in accordance with the provisions of the Act. And the agreement to adjudicate has to be in writing, and it is deemed to be in writing if it is signed by the parties, or if there's an exchange of letters or telex or telegram, email, or other means of telecommunication between the parties. The whole idea around it is because it is an elective process, so there has to be evidence of that agreement. And then that agreement to adjudicate must also nominate an adjudication body or provide for the procedure for the appointment of an adjudicator. So that it is clear how the process will proceed. So going on to the payment claim, in submitting a payment claim, so where a party, so for instance a contractor or a subcontractor has a payment claim, how it is submitted is it must be submitted in accordance with the terms of the construction contract, but not later than at least 30 days from the date that the claim becomes due or arises, or from the date of completion of the contract. Then once the payment claim has been submitted to the other party, the receiving party must then respond by submitting a payment schedule or a schedule to pay less. And this schedule must be submitted within 21 days from receipt of the payment claim. Now, the schedule to pay less should specify the amount payable if different from the amount stated in the payment claim, and it should also specify the reasons for the difference. Upon receipt of the schedule to pay less, the initial party shall either accept it in whole or accept it in part, or reject the amount. If the amount is rejected or is accepted in part, then the initial party then must submit a notice of a reference to the construction adjudication body within 7 days. And you will notice the timelines are quite short, and it's deliberately so. So once a notice of reference is submitted to the construction adjudication body, an appointment of an adjudicator is made within 7 days. And that notification is then sent to the parties that an adjudicator has been appointed. Once the adjudicator has been appointed, the referring party serves the reference upon the responding party and adjudicator within 7 days. And in turn, the responding party will submit their response within another 7 days. Then the adjudicator has 14 days to determine this reference. The adjudicator also may also determine it within a longer time, but it has to be by consent of the parties to do so. Let me just move on to my next slide. So the determination of the reference, the adjudicator may require additional written submissions from the parties, or may ask for a conference between the parties, or may require to hear a party or any other relevant person to the dispute, or may even require an inspection of any matter related to the claim. Once the adjudicator has considered all these issues, then the adjudicator must deliver his decision. As Jackie had mentioned, it must be a reasoned decision, and that decision should be accompanied by a certificate, where the certificate will specify the amount, if there's an amount that is payable, and the extent of that amount, and if interest, for instance, is applicable. Once the adjudication decision and certificate is presented, then payment must be done within 7 days, or such other time as the adjudicator may, provide in his decision. Then, if a party is if after the adjudication certificate the same is still not yet has not yet been settled, then a party is entitled to enforce, and this is one of the attractive things about the adjudication under this act as compared to other forms of adjudication, for instance, that you will see in the FIDIC form of contracts or in the JBCC contracts, where the adjudication certificate can be in now under the statutory provision. This adjudication certificate can be taken to the High Court for enforcement, and the procedure for enforcing it is, basically just applying for it to be converted into a decree, so that you can, enforce it like any other court judgment. If you compare it with what you have in the FIDIC forms of contract, the adjudication decision is, it is interim binding, and although it is interim binding, there is no really provision for enforcement for it. So this statutory adjudication is really, I think, is a timely provision, because it provides a quick way to enforce it, so as to align with the principle of, pay now and, argue later. Then one of the things, the features of enforcement that makes this attractive as well is that if a party, for instance, is aggrieved by the decision of the adjudicator, they may apply to set it aside, but the grounds for setting aside have been narrowed down. And then been narrowed down to only 3 grounds. And one of the grounds is that either there's the adjudication decision was procured by fraud or corruption. That's one ground. The other ground is that the adjudicator did not follow the act in reaching his decision, or the adjudicator has acted in excess of his jurisdiction. So there are very limited grounds, so as to ensure that the payment is made as quickly as possible, and arguments as to other aspects of the dispute are argued in a different forum. Another attractive provision about the statutory adjudication when it comes to enforcement is that when you apply to set it aside, then you must deposit a security for costs. And the security that should be deposited in court is the amount that is in the adjudication certificate, to the extent that it has not been satisfied. And this really is, to discourage, frivolous applications for setting aside, so that parties don't take advantage and erode the expeditious process that was carried out before the adjudicator, and just file an application for setting aside just for the sake. So that security for costs is a very good feature, just so as to make sure that it is only the very genuine cases that would proceed for setting aside. And then the application to set aside also must be made within 7 days. So the window for which to lodge that application has also been limited, so that parties do not erode the speedy process that was done before the adjudicator. So those are some of the unique features of the adjudication under the statutory adjudication. I think also another interesting feature under the statutory adjudication is that it has expanded the application to include many more parties within the construction ecosystem. So if you look at the definitions of what a construction contract is, and the people who may refer a payment dispute to an adjudicator, it includes parties who, for instance, subcontractors. It includes parties who may have provided labor for purposes of carrying out construction works, or parties who may have provided construction materials or equipment required for construction works, or or preparation of an architectural design to conduct a survey. So it has really broadened the application so that it can cover as many people as possible in the construction ecosystem. So I believe those are some of the unique features of construction adjudication under this statutory form of adjudication as compared to other contractual forms such as the FIDIC or the JBCC.
Thank you so much, Desmond. You have really gone in depth into setting out the key features of the bill. And what I hear from you saying is that because of enforceability, timely dispute resolution, and the expanded ambit of the bill, then it presents a better solution compared to what we currently have. I think I will now jump into how the bill, to the people who are on the ground. So let's look at how the bill affects those people on the ground, the engineers, the contractors, the quantity surveyors, the project managers, those who ideally deal with payment disputes in real time. So my question is to you, Engineer Alwoch. From your experience working in construction projects, what are the main points in resolving payment disputes? And in your view, do you think this bill addresses those challenges effectively?
Thank you so much, Paula. Sure you're able to hear me.
I hear you loud and clear.
Thank you so much, and to my fellow panelist, Emerita and Mr. Desmond Odhiambo. Thank you for doing justice to this document with your clarification on the same. This document is a good platform. It has some few issues here that need to be probably checked and corrected. And this is the time I'll not walk us through detail one by one, but I'll make some general submissions and comments on this document that are direct. I know Mr. Diambo have looked at it, and there are some things that Mr. Diambo, as a lawyer, you are not able to understand properly. To me, my biggest problem is that I am a paralegal practitioner, and again, I'm an engineer. So I've spent some time with this document, and there are some things I understand about it that are not really what the ground is saying. I don't know which ground, but what I know is that the ground where I stand in as an engineer, there are some things that are not clear on this document. First, I'll start with the preamble of this document. When we read the preamble, or the title itself talk of Payment Adjudication Bill, our preamble talk of payment and other remedies. What are these other remedies? Is it construction quality? Is it delay time analysis? Is it information request? Is it delay in design? What are these other remedies that this document seek to cure? My submission is, one, we either change the title of this document or amend our preamble. Two, when it comes to the definitions, you've talked about the definition and all that. Not bad. But probably I'm also here just to shed more light for other our listeners, or the people before us today can also just interrogate the document and understand. The definition that have been given as construction work and construction contracts, there is a problem. And if at all you are saying it includes even the consultancy, it is not clear. And we all know what consultancy means. This document excludes all the consultants' practice in the payment issues. It is not very clear at all. I've made my submission this evening, and probably I hope it will reach NCIA, of what I perceive to be the definition of construction contract. Construction contract should include two things, in my understanding: the construction work contract and construction consultancy contract. And then we should go ahead and define what are the construction works and what are the construction consultancy services, so that it comes out very clear, so that anybody reading this document will be able to correlate the two. While I was looking at this document, I remember probably the global basis of adjudication, the Housing Grant Construction Regeneration Act of 1996. It was a precursor, a precedent of a report that was done by Sir William Latham in 1994. I got back and asked ourselves, this document, which report has led to its production? We are not told. We are not sure. I think my good friend, the Emerita, said that 600 people were consulted. Probably, I'm not very sure. But then, what are the main problems that we have in this construction industry? If at all we've left a major one, the consultants. That's that. I move forward just to highlight some key issues. And Paula, please be on the lookout so that I don't talk so much. I have some serious problems with some definition. You are talking of the council. I think it refers to a different document. That is the dispute bill, or which will also soon become a dispute act. And this one I've said time and again, we are talking of construction payment. The body that is to foresee the development or to foresee the practical areas, as Jackie put it, there is no engineering institution representative in that council. What does it then mean? Then this document is not for construction. It must be for something else. Actually, that council has almost 50% of them lawyers. So it cannot be for construction. In my understanding, it must be for something else. We are yet to find out what it is for. With the different definitions, I think the problem here and there, we can argue about it and probably adjust. I move ahead. Between Section 4 and Section 5, there is something we term the trigger or dispute crystallization. You know, when a contractor submits payment certificate, or IPC, we call it so, the next thing is usually valuation, or if not valuation, then we do what we call as remeasurements. In most cases, the remeasurement value is usually lower than the value that the contractor has submitted. Do you want to tell me that once the remeasurement has been done and the value is less than the amount submitted by the contractor, is that one a trigger for dispute? I'm not sure. This document has failed to address that. So in terms of the trigger, Section 4 and 5, I have a problem with that. Then consideration of the payment schedule. The definition that has been given as payment schedule. In construction industry, we have payment certificate, interim payment certificate, payment schedule. This practice is largely in the UK. In Kenya and in Africa, I'm yet to see where the employer is mandated to give how much will you be paying periodically to the contractor, because in most cases we do interim payment certificate, which is remeasurement or valued work, and then it is paid with a given threshold. I don't know if at all the contractor has not met the threshold as required by other document, let's say like JDC. Will that one be a trigger for dispute? Not sure. That one doesn't exist. Section 7 and Section 8, in terms of the adjudication process, parties still have no opportunity for the appointment. The dispute, the claim need to be accompanied with the fee, the what. I may not have a problem with that. That's why I say that the baby is not badly off. He can survive. It's only that we must see of how to feed him or probably help him. In terms of the service of the referrals and the timeline, as my friend, my namesake put it, you know, when payment certificate is raised, then this document say that after 30 days when the claim was due, and then the process proceeds and all that. In my understanding, there is a big problem here because this document has failed to address of when I've submitted this document, my claim for payment, and we are in the process of adjudication. What happens with the works? Do they proceed? Do I vacate the site as a contractor? As a consultant, do I still continue working? What happens? This document has not addressed that. It is in my submission that we need also to clearly define, while the the adjudication process continues, what happens with the works? Do I close the site?
Engineer, allow me to pause you there.
Let me just give overview, then finish, so that I can create room for others also to just comment.
Okay, I'll just 2 minutes so that we can have a robust overview. And I think some of the questions that you're asking, Jackie can be able to address them in the next few minutes. But I think it's very important that the questions you're bringing. The idea is to have participation from all sectors of the construction industry to make the discussion as robust as possible. So thank you for your submission, but I'm only adding you 2 minutes.
Thank you, Paula. Just give me those 2 minutes so that I can probably highlight 2 or 3 things. But my friend Jackie commenting, I think some of these things have no justification why we should exclude them. Generally, it is only to submit that let's agree that this baby was malnourished and we need just to feed him and make him survive. Thank you. My friend talked of the adjudicator's decision or adjudicator certificate. This document does not justify that the adjudicator's decision should have a reason. Please, I'll take you straight to section 16. Read section 16 up to G. There is no reason that the adjudicator's decision should have a reason or should be reasoned decision at the end of the day. So this document has failed to address that. And I'm wondering, how will I change the payment certificate or payment claim from 15 million and say that this contractor ought to have been paid 20 million without saying, justifying why should he be paid? Or why should it move from 20, or from 15 to 10 million? Paula, you cut me short. I'm looking at section 22 on the issue of application of setting aside. The window that have been created by this document is so narrow to an extent that, in my understanding, it will be subject to an abuse by other people. I submit that this clause needs to be expanded. Section 31 and 31 talking about the issue of the liability or the responsibility of the adjudicator at the end of the adjudication process. In my understanding, we need to expand this also, because at times now, some people or some parties may bring in that the adjudicator to appear before probably court or other tribunal for the purpose of giving evidence. Should this probably the other party submit for setting aside? I think those liabilities should be, the adjudicator should be exonerated from such kind of liabilities. Finally, probably now to leave it there, there is something I wanted to say about the powers of the adjudicator. I think that one is also not properly narrated in this document. And just to finish, sorry. Just to finish there, what I may say at the moment is this is a very good document, a very good foundation. What we only need is to agree that there are some things that were missed out of it, and we just need to bring them in and revamp this document and make it robust. Paula, thank you. I hope I have not offended the sitting panelists. Thank you.
No, I think your submissions were very useful. Thank you very much, Engineer Loach. And as I said, the bill is still out for public participation, and these are the comments that we would imagine would come in to make the baby as nourished and as healthy as possible when it's finally birthed. So to let those points sink in, I want to move over to Dr. Henry Murigi, and just talk about the role of the NCA. You serve as the chair of the NCA, which administers disputes. Could you please talk about the role that the NCA plays under this framework, and how does it interface with existing alternative dispute legislation and policy?
Thank you. Thank you so much, Paula. I want to thank ACL for putting this together. In fact, I was just thinking how important it was that ACL has considered to take this as one of their initial or the first webinar to discuss the Construction Payment Adjudication Bill. So I want to congratulate you also for putting this up, and thank you so much for those robust comments that are coming through. And I want to begin by saying that the whole idea of public participation, as you said, Paula, is to allow as much and as vibrant responses to the bill as possible. So when I listen to Engineer Aluoch and his very passionate comments about the bill, I am so delighted, I'm so elated at the idea that the bill has been well received and has attracted the attention of engineers as it should. And I'm glad that he takes a view that the bill is a baby, alive, only malnourished. So it's a question of just improving it. So that's a healthy view, and I take in all the comments. And Engineer Loach, I want to assure you, I am here. I'm not the chair of NCIA, but the registrar CEO of NCIA. So NCIA is listening keenly and taking note of all the comments that you have said. For instance, I want to say I totally agree with you that in the definition section, we have not defined the what is it called, the council. The council has not been defined. So certainly, if it's being referred to in the act, then it means there's a totally there's an important part that is missing. Paula, let me just say three things. One, the bill has to be understood in the context within which it's being brought up. And I think Chair Emerita mentioned that the bill is part of a legislative attempt that is crystallized by the national ADR policy that is tabled in Parliament pursuant to being approved by Cabinet in 2024. And as, of course, Chair Emerita mentioned that it was a product of vibrant discussions with stakeholders and many players who are in the industry of dispute resolution. So it comes within that, and there are three bills that are being put forward for consideration. Number one is the amendment to the Arbitration Act to make it up to par with global practices. The second one is the Construction Payment Adjudication Bill, which is what we are discussing today. And the third one is the Dispute Resolution Bill, which seeks to address questions of mediation and conciliation. Those are the three legislative initiatives that are being attempted by the national ADR policy. I must say that, yes, when you read it in isolation, you will see some obvious gaps in the construction adjudication, payment adjudication bill, because it cross-references to certain other provisions of the dispute resolution bill. So there is a need for those documents, or for those two pieces of legislation to speak to each other. And I totally take the comment by Engineer Alwatch on that. The second thing I want to say is that, and to your question, you asked what is the role of institutions in this. First of all, this is, I think, as Chair Emerita said, an initiative that will set Nairobi and Kenya generally as a trailblazer, a city that, or a country that is looking at offering and bringing order and justice in the construction industry. So we are looking at making this as one of the pillars of our commitment as a state and as a nation to alternative dispute resolution framework. So the idea is to make sure that we are promoting ADR and in its various formats. Now, NCIA, Nairobi Center for International Arbitration, is an institution that is created by an act of parliament. Under Section 5 of the act, we have our mandate. Our mandate is stated there clearly as to what we should do. One of the things that we do is administer disputes. And in particular, we administer disputes that are international commercial arbitration disputes. But the Act also gives us a broader mandate to administer all other alternative disputes resolution mechanisms within our auspices. So what this bill is likely to do for us is likely to expand our ability to administer disputes in the construction industry. So we are certainly going to look at our internal rules and begin to think how we can administer disputes. Nairobi Center for International Arbitration is the only body here in Kenya that administers disputes. Most of the other institutions are offering dispute resolution, capacity building in the dispute resolution, but Nairobi Center for International Arbitration is one that does that. So we have facilities. that we use for dispute resolution. We both online and physical facilities that we could use for that. So we are ready for the players in the construction industry to begin to accept, to begin to appreciate our role and to also take advantage of the facilities that are available for that. The third thing that I want to say in relation to this bill and in sort of a reaction to some of the comments that have been said, when a legislative attempt is being made, some of the things are idealistic. And one of the things that makes it more practical is the comments that come in, so that then they can sit in with practice. And I want to congratulate ACL for allowing for this to happen, where we get direct feedback on what the real industry is what it looks for the industry. So I want to say that this whole framework must be looked at in the context within which construction disputes are being done. And to comment on one or two points that Engineer Aloch talked about, if you look at the bill, the National ADR policy, you will see that the attachment or the annexure to the bill is a bill. The annexure to the policy is a bill called Construction Adjudication Bill. But if you look at what we put out is the Construction Payment Adjudication Bill. That is after we engaged with the Attorney General, and the Attorney General looked at it and made it clear that this bill seeks to deal with questions of payment. Of course, there are discussions that are going on as to whether we should limit it to it, and I think those comments will be considered and then placed before the relevant body, that is the National Assembly, for consideration. So I just want to say in conclusion that when I see or rather I have put in the chat the comments, the Google forms that would allow you to just put in your comments and justifications for every section of both the Construction Adjudication Bill and the other two bills that are being legislated on. So I want to invite all of you to take part, and as vibrant and as many responses as can come through will be very welcome. In fact, from our international audience, I'd be very happy to hear what their industry or what their context would look like when they look at what we are attempting to do, so that then we can improve. Lastly, I thank you very much, Paula, for bringing across, I think, Africa. I have seen so many people from all over Africa to discuss this great initiative. So I must thank you and congratulate ACL for this. Thank you so much.
Thank you so much, Henry. And just members of the audience, I can see people from Morocco. I can see my friends from Nigeria. I saw someone from Kigali, Mauritius as well. It's really a pleasure to have these conversations and to know that it not only affects Kenya, but it spills over to the continent as well. So thank you so much. You can send your questions. I can see some flowing in the comment box. We have a Q&A session at the end of the session. So most of the questions will be addressed. But as Dr. Murithi said, some of them are coming in as comments. So you can either just paste them directly into the link that has been shared. But we as ACL will also take into account all the discussions that we have here and send the comments for as part of the public participation exercise before the 30th deadline. So Dr. Murithi, allow me to just ask this question for the sake of the young and upcoming adjudicators in the audience. Are there any opportunities for training, accreditation for adjudicators under the bill, especially those with backgrounds in engineering, law, and quantity surveying?
Thank you so much, Paula, for that question. And I think this is one of the things that, to answer your question directly, Engineer Loach alluded to, that the bill doesn't necessarily capture it very well. However, there are so many opportunities for training and capacity building around construction adjudication. I know, for instance, the Chartered Institute of Arbitrators have a program for training adjudicators. There are many other opportunities that will arise if this bill was to see the light of day, and we pray it does. Please pray with us pray and fast if you can, so that we push it so that it goes through. But to answer your question, yes, there are so many training opportunities. NCIA is mandated by statute to build capacity around ADR. So we see this as a golden opportunity for us to enhance our ability to reach out to a wider market and a wider array of professionals and players and stakeholders in the industry, in the construction industry. So, for instance, we see this as an opportunity to reach out to the contractors, the engineers. I think we are reaching out to them. Was with the CEO, registrar CEO of EBK. We are reaching out to all of them and inviting them to engage in this. So there are many training opportunities, even for lawyers locally, to be able to understand this industry. I think if you sit in with Engineer Aloch, you'll be able to understand much better how the construction industry operates and how dispute resolution is done within the context of construction. Engineer Loach, I wanted to suggest that when we are collating the comments, maybe I can reach to you on the side. We can look out for you to make sure that your comments are part and parcel of what then becomes part of the bill. So I think I'll get your number somehow, and then we can reach out to you so that then you can help us enrich and persuade. For instance, when we are discussing with the Attorney General, the officers who, or rather the professionals who do legislative drafting, there's usually a pushback, and it's a process. So when we have industry players who understand the industry better, you are able to then articulate it much more profoundly than perhaps we could. So I'll be reaching out to you, and to anyone else, please feel free to share your comments. Thank you, Paula, for this.
Thank you, Mr. Ndoti. I would like to.
Can I say something about training?
Yes, in fact, I will say to you, Angela.
Thank
so
you.
Do you want to say something first, or do you want me to ask
on the training?
Sorry?
On the training, just specifically on the training.
Okay.
I know Dr. mentioned this, but CIF does train on construction adjudication. And we have all the way from introduction to construction adjudication. I've been the course director for that particular training. And it's very exciting. So for those who are interested, please take just look out. That is the way to get in. And it is a graduated training approach, so that once you're done with the entry course, then you go to module 1. If you're a lawyer, unfortunately, engineers might have to campaign for you to be included in this, but you can do the exemption, that is module 2. Module 2 is really just contract tort and a bit of evidence. And then there's module 3, which is the highest level. And then you become a fellow construction adjudicator, similar to what we have in arbitration. And once you've done a number of construction adjudications, this is something which is very new. It is so new that it came in under King Charles. We got the new royal charter because every monarch comes up and renews the charters. So now we are also allowed to have chartered adjudicators, and I'm hoping that engineer, you will take up that challenge, and many others will take up that challenge. And then there are others. There's the DRBF. They do very interesting trainings just on how the dispute boards work, because there's a slight difference to construction adjudication. There's King's College, and then there's FIDIC. FIDIC is probably the best known, and there's construction adjudication, several levels, three levels, and then you can become a certified construction adjudicator, if that is what I understand. And this one has advantage for engineers, so you might also want to consider that. Okay, that's all I wanted to say.
Thanks, Jackie. And if I may, the ACL Academy also offers an introduction to construction law course that is open to all professionals across the board. And I think for the benefit of also our audience across Africa, it would be a good introduction and an opportunity to network with colleagues across the continent and also share ideas. So back to the question, back to the topic at hand. As we host our colleagues across Africa, perhaps, Jackie, it is important not to view this bill in isolation, because we are looking at it as part of the broader movement to improve dispute resolution in construction across the continent and the world over. So perhaps you can tell us from your experience in drafting the bill, How does this bill compare to construction adjudications in other jurisdictions? And what were your best practices when you were looking at it?
I think probably the place to start, when we started discussing this, we acknowledged that probably even more active than what we have in Kenya is South Africa. They have a very developed approach to construction adjudication, but theirs is specifically contractual. In fact, I can say it's almost solely contractual, so that most of it goes through the process of either a DB, the FIDIC contracts, and then those that are probably ad hoc would have the bespoke. They had an approach they were trying to bring in, and as approach similar to JBCC, to have a construction adjudication and then send it to expedited arbitration, and then they'll be able to enforce. So when we sat and we thought about what is happening elsewhere in Africa, we thought, okay, well, that's really well and good, and we can actually put it in place. And you'll be surprised that we are the ones who came up with that particular idea in Kenya for the JBCC, which never really took off, and then we had to revert to 1999. So we looked, of course, the first place we looked at, because that was the birthplace of statutory adjudication, was the UK. They call it England and Wales. And we really relied a great deal on the housing, call it Housing Development Construction. I call it the Hughes Grant Act. So sometimes I forget the Housing Grants Construction and Regeneration Act of 1996 in the UK. One of the other jurisdictions that we found to be very, very successful in this regard was Singapore, but Singapore is really efficient in putting in place ADR mechanisms. So it works in seamlessly with arbitration and mediation as well, because mediation is also up and coming in construction disputes. And Malaysia and Hong Kong at that time were trying to put theirs together. There was also Australia. The Australian model is a bit, it's interesting because they have two formats, East and West. So we took the things we thought would be of benefit to the Kenyan scenario, and that is what you see largely in part to the Construction Payments Adjudication Bill. When we sent it to the Attorney Generals, and this is the draft document, we called it the Construction Adjudication Bill. Of course, we focused on payments, and they picked that up and they have made it the focal point. But one of the reasons we didn't include the term payment in the bill was because payment arguments can come and they can stem from many different sources. So talk about delay, talk about extension of time, talk about extenuating factors, and just calculating that has an impact. And usually there's a monetary impact. So we thought that if we make it about payment, it will be an umbrella cover also within the context of construction adjudication or dispute resolution that will enable a whole spectrum of dispute resolution questions, if you like, and even the normal haggling. So the schedule, the payment schedule. I wasn't really aware that in Kenya we don't use that much. I've heard that today from Engineer Luch, and I'm curious to see how that will impact what we end up having here in Kenya, and also to see then what happens with the rest of Africa. Now, the one thing I want to say about Africa is that first, we have not really been trading with each other. I think the numbers that we have, and they have been the same for the last 10 years, this before we started talking about after we signed after, and even post after, as we are trying to put everything together, it's 15% trade with each other. The goal under the convention now is to raise that number to intra-Africa trade up to 80%. And you cannot do that without developing the infrastructure in our countries. That is the one thing that will equalize everything, to provide a platform for the movement of goods and services to the different countries. So when we say we are putting this in Kenya, and it was very deliberate to say partly, wholly, and not make it necessarily situate in Kenya only, is to provide a a platform to say to look at NCIA, for instance, as a platform where you can have institutional construction adjudication and arbitration. I know they are working on this, and I know once we have the acts, very soon something will come up. Dr. You can thank me for this. And ultimately, as we move forward, then we will have an impact on how dispute resolution I say including, because today we're talking about construction adjudication, but it's the whole spectrum under our constitution, and also the recognition that dispute resolution is cross-border for the large part. And then factoring in that once we have one community, then we should be able to think about where are we going to be resolving this dispute, because that question will continue to arise. So I'm thinking that this will be a first step to be able to realize an Africa that trades with itself, and an Africa that is able to, once you trade, of course, there's commerce, but commerce comes with conflict, and conflict resolution demands that we also have a cognizable framework that we can say, this is what Kenya is doing, what can the rest of Africa do? I know Zambia, I know Kigali, that's Rwanda. They've also been really developing their dispute resolution spaces. And I know construction adjudication is going to be an area that they will be interested in exploring in depth. So this is an opportunity to lay the groundwork. At the very least, knowledge management, knowledge exchange must happen between our African countries. I didn't leave out Nigeria deliberately. Nigeria is also big. They've just done their, they call it ACA. I hope I got it right. I was at AMA, sorry. Arbitration and Mediation Act. They did that in 2023. They've created a platform. I know that they will not be far behind in considering an approach that will reflect a unified approach across Africa. So when I say, this is one of those watershed moments where we'll remember and say, no, in 2025, we discussed. Hopefully our parliament will come through, and ultimately we'll be talking about the gains that we have made, the mistakes that we will make. That is inevitable, but I like the bath baby analogy. It will grow and it will crawl and then it will walk, and ultimately the beneficiaries will be us. Thanks.
Thank you. Thank you. I think that's a good place to pause this discussion and not stop, obviously, because we can continue it online. In the interest of time, I would like to give a minute to each of the speakers to just give some closing remarks and maybe give some comments on how the industry stakeholders can interact with this bill during the public participation phase. I'll start with you, Desmond, in 1 minute or less.
Yeah, thanks, Paula. So maybe in my concluding remarks, I think the initiative is good, and I like the fact that the adjudication is limited just to the issue of payment, and rather than expand it, to determination of all, other kinds of disputes such as delay and so forth. So as mentioned by Engineer Lodge, the preamble should be amended rather than to expand the scope of the adjudication. So I believe it should be narrowed just to the issue of payment. And the reason why it should be on the issue of payment is so as to nurture the construction industry, because even if you look at the statistics, there were statistics published by Deloitte where they did a survey of the sectors that are vulnerable to insolvencies, and the construction sector was one of the top sectors where there are many insolvencies, and that is because contractors, especially the mid-tier contractors, are being forced to wind up their businesses because of delayed payments, and therefore this provision of having a provision where you can determine disputes on payment in an expeditious manner is really aimed at being able to protect the construction industry so that we can grow to the next level. One of the questions I've seen in the comment is, why the construction adjudication has to be provided, by way of contract. That you can only access it if it is provided for in a contract, as compared, for instance, in other jurisdiction. I think it's Canada, where you have the right to access a statutory adjudication, notwithstanding that you may not have provided it in your contract. I think that's a very valid point, and maybe something that the committee should consider, so that, because if you look at especially the smaller players in the construction industry, they do not have the an equal bargaining power, with probably the employer, or a main contractor, and you may find that they have not provided for an adjudication in their contract, as a form of determining issues of payment, or even other forms of construction agreements, for instance, the consultancies or the provision for building materials. So in such instances, they should be allowed to access the forum of adjudication, notwithstanding that it was not provided for in their agreement. Of course, carving out a provision where, if there was already an express adjudication procedure in the agreement, then that excludes you from accessing the statutory adjudication form. But I think that's a very valid point. Yeah, I think I'll leave my comments at that.
Thank you, Desmond. And I've noticed that you've answered quite a few questions in the comment box. Specifically, one that keeps coming up is whether these provisions have to be incorporated in the current forms of contract. Is this a legal requirement moving forward? And do these provisions supersede the existing payments, claim and dispute provisions in, for example, FIDIC contracts? So I think you've addressed that in saying that it's at the option of the parties. Okay, I'll move on to Dr. Murigi, closing remarks. And probably if you have any questions that you're seeing that you'd like to address in the comment box, this would also be a good time to do that in the interest of time.
Thank you, Paula. I think we had an agreement that for any hard question, we know where to direct it. That was agreed as a ground rule for this webinar. So please let us stick to that. Jackie is here. She has the institutional history and everything that goes with it. But I can say in closing, I think I've seen a question from Roy McPhail, I think, from Canada. He's asking whether we did a comparative study on I think the same question you asked. Maybe my comment would be, I mean, Jackie has the answer, but the bill, the policy sort of captures exactly what was done. So perhaps it would be a good thing to interact with the policy as it is. I think it's available on our website, and if you can access it, you'll then get all the relevant material that informed what the bill is about. And then perhaps if you identify a gap, feel free to comment. And it's actually very much welcome to have comparative perspectives and comments from all over the world. So I truly appreciate that. So my final comment is to say thank you for the panelists. Thank you for ACL putting this together. We at NCIA are very happy and glad to associate with this great successful webinar, and we look forward to more of this. And I want to invite everybody in the call. Please feel free to put in the comments in either the link that has been shared by ACL, or go to our website and put in the comments. Let them come, let them come, let them come. Read the bill, the acts, I mean the policy, and please give us as much comments as possible. Other than that, I want to thank you very much and have a good evening. Thank you.
Thank you very much, Dr. Murigi. I'll jump on to Engineer Lodge, noting that it's a Friday and it's payday Friday. Please give your closing remarks in 1 minute.
Paula, that one will be quite unfair. In the Middle East, it is not Friday, and that is where I am. So in 1 minute, I'll comment on what my good friend Udhiambo has said. It is true in Canada, in UK, England, and Wales, there is what we term statutory adjudication. If at all it is not included in the contract, the scheme by default become the act. So by default, whether the construction agreement was just verbal, by conduct, whichever means, our act is not very clear on that. What our act or our bill is providing is, if at all it is provided for, or the contract which you have as provided for, how to adjudicate payment disputes, then this act does not apply. But if at all it doesn't, then this one will apply, and again, it must be in writing. That's one. But for statutory adjudication, I think it's a good way to go, generally, because we know our nature. Most of our contractors, some of them are not well-schooled. Let me use that terminology. Some of them are not engineers. So if at all we guide them in this direction, to me, I think we'll have a better industry. That's one. Two, on the issues of dispute and the days to resolve dispute, like in the UK, it is 28 days. 28 days, 14, then another 14, if at all the parties agree, and all probably by the application by the adjudicator and all that. Why has it become so effective? And in my studies, the reason why, in the UK, it is one dispute to be referred to the adjudicator at a time. You cannot take time analysis, payment problem, to the adjudicator at the same time. It is one dispute at a time. I think that's where the 28 days is working, or the 42 days or so is working. But now with us in our industry, especially in Africa, you'll find payment per se is not an issue. Sometimes the claimant, the contractor was given information late, site access was given late, there's delay analysis, there is a weather issue and all that. So you will find that the contractor is bringing you bulk, and our legal practitioners knows this. You will be given 1,000-page document, and then you are told, can you please resolve this thing within 28 days? It will not work. That one will be creating another dispute. Otherwise, because Paul, I can see, she's looking at me, I'll rest there and say, thank you. This is a good, the baby has not been under stillbirth. He's normal, he's okay. He's very fine. But then we need to feed him well so that he can grow healthy and he can grow with some stamina and vigor. Because I know very many people are looking forward also to give birth to this kind of a baby, wherever this one came from. But I'm very sure in Africa, very many people are looking forward to it. Otherwise, I'm very grateful. Thank you for the opportunity to share my experience. Thank you for all our attendees. May God bless you. Have a good evening. Thank you.
Thank you so much, Engineer Loach. You have made the conversation very lively and robust. Lastly, but definitely not the least, Jackie, could you give us your closing remarks?
Yes, thank you. Thank you so much. And I really enjoyed also participating with my fellow panelists and the good questions that have come from everyone. I will mention, because the question came up, that we did not really consider Canada. But at the time, one of the things that we tend to think about in this part of the world is that we already had the Englands and Wales. We had the representations from Canada, which I think is also a fairly federal approach to what Canada has. And I think predominantly we're looking to see what South-South was also doing so that we could also get the viewpoints. There's not much that we're able to get, but then what we did was to defer to Singapore. Malaysia hadn't done theirs, and neither had Hong Kong. I think Indonesia had some sort of a draft that we could look at. So we did look. We tried to be as broad spectrum as possible. It was not possible to look at each and every jurisdiction in the world. There are almost 200 of them. That's the first comment I wanted to make in response to the question. On this issue of time, 28 days. And I will say this because I have, as an adjudicator, resolved disputes with more than 1,000-page documents, but within 28 days. And some of the tactics that we use, we teach them. So this is what I will encourage you to come and see how it is possible to tell the parties, no, you're not going to exceed the time. The time limit is you 7 days, the other party 7 days, and I 14 days. I will give you a decision and you will get it before midnight on the day when it is due. And they have been enforceable and people have followed through. So there are many different dynamics about that, but pay now, argue later is a philosophy we need to inculcate in our jurisdiction. And I'm looking forward to see how it pans out. On the question of subcontractors, one of my inroads into construction adjudication is because I was registered under NCA. I am a contractor also in another world. So I was looking out for them as well. And it may not be apparent, but when you look at the way we couched the agreement to adjudicate, we said first it must be in writing. Yes. Secondly, we said that it needs to be signed or. So there's an alternative. The or is the exchange of letters, email, and any other telecommunication, which could also mean WhatsApp. So we're in for an interesting ride as we move along. And therefore, what it means is that the contracts, what you call them, standard form contracts, the FIDICs, the JBCC, those ones will be signed, they will be initialed, hopefully, and they will be formal. Those that are not formal will fall under this act. So we can expect quite some jurisprudence to grow in relation to what does it mean to be an agreement in writing. So that was very deliberate, and I'm glad the drafters picked it up and they put it in the final document. The last thing I'll say, the adjudicator's decision, it was in the draft we sent to the Attorney General's office. I'm not sure why it didn't make it. I believe that's something that we can throw back into the memoranda that we're going to be writing. So to my colleagues on the platform from whichever part of the world you belong to, Africa is, and this is a direct quote from a professor who said this a few Paris weeks ago. Africa is the El Dorado of arbitration. Africa is the El Dorado of dispute resolution. Everybody is coming here for the obvious reason that we are growing. And wherever there's growth, wherever there's trade, wherever there's cross-border interaction, ADR, and particularly arbitration, then secondly, what you're trying to build here, construction adjudication, is definitely going to make a huge impact. So I'm looking forward to this ride. It has been interesting so far. It's going to get really exciting as we move along. Thank you so much, Paula and ACL, for the opportunity to engage with this very nice platform on a Friday. Is it Payday Friday? Friday. Enjoy yourselves. Cheers.
Thank you. Thank you so much. And thank you to all in attendance. I'd like to invite the chair and founder of ACL to give some closing remarks before we close. Mr. Ngo Martins, are you online? Okay.